Welcome viewers to part 2 of our screencast on long-term care issues in Medicaid. My name is Richard Land. I'm an attorney and a member of the Danbury, Connecticut law firm known as Chipman Mizuko. In part 1, we talked about the kind of services Medicaid covers, and we began to talk about the criteria used to determine if you qualify for Medicaid. In particular, we talked about how your income affects your eligibility. Now in this part 2, we'll be talking about how your assets affect your eligibility. As we mentioned earlier, Medicaid is a welfare program. That means that you qualify to receive assistance under Medicaid only if you do not have enough of your own resources to cover your long-term needs. We just finished talking about the income side of the equation. Now let's talk about your assets. The bottom line of the asset side is that you're required to use all your resources on your long-term care before you can qualify. That means you'll not be able to qualify until you have used up all but $1,600 of your countable assets. We'll get into the meaning of the term countable assets in a few minutes. The point is, if you're unmarried, you qualify only when you have virtually nothing left. But there are exceptions, some of which we will talk about later. Married couples are considered a unit for this purpose. In other words, except for an amount called the Community Spouse Protected Amount and the primary home, all the assets of both spouses will be counted as available for the care of the institutional spouse. In other words, for the institutional spouse to qualify for Medicaid, all the assets of both spouses must be exhausted except for the home, the $1,600 which the institutional spouse is allowed, the Community Spouse Protected Amount, and some other assets which are known as excluded assets. One important exception relates to certain long-term care insurance policies which we will discuss later. When we are looking at the asset limitations, we're looking at only countable assets. Countable assets are everything except certain specific assets called excluded assets. The excluded assets are the principal residence of the Medicaid applicant or spouse if the equity is under $840,000, essential household items, personal effects, burial plots, burial funds no more than $1,500, and irrevocable burial funds of $8,000. Non-home real property is also excluded if you agree to sell it. The principal residence will be considered non-home real property if it's clear that you will not be returning and if your spouse or minor child or disabled child is not living there. A motor vehicle may also be an excluded asset, and it can be a pretty fancy vehicle if it belongs to the community spouse or is needed for employment or medical reasons. Otherwise, the limit for the value of the vehicle is $4,500. Term life insurance policies are excluded. Cash values of life insurance are excluded if their total face values do not exceed $1,500. Also, certain countable assets may be deemed unavailable and will not disqualify you from receiving Medicaid assistance if the fact that they are not available can be verified and if you cooperate in trying to liquidate it. An example of an unavailable asset might be a life estate in real property which cannot be sold. Earlier, I mentioned that when a Medicaid applicant is married, he will not be able to qualify if the value of his spouse's assets exceed the home plus the Community Spouse Protected Amount. Now let's talk about that, the Community Spouse Protected Amount. The Community Spouse Protected Amount is the amount that the community spouse is allowed to have in addition to the home without disqualifying the institutionalized spouse from getting Medicaid benefits. It's based on assets as of the date that the institutionalized spouse is admitted to a facility when institutionalization goes on for a continuous period, or as of the time when there's a determination of a medical need for community-based or home-based services. We'll talk about community-based services a little later. So there's a point in time when your assets are reviewed in order to determine the Community Spouse Protected Amount. As of that date, which is commonly the date you're admitted to a hospital for treatment, you'll need to put together a list of all your assets and your spouse's assets. exclude from the list all the excluded assets. We just talked about excluded assets like the home and personal effects. And you're left with the countable assets. And it's important to note that the assets are not reduced by any debts. So you could have $100,000 of countable assets and $150,000 in debts, and your countable assets will be considered $100,000. The debts are not considered. To determine the community spouse's protected amount, you divide the countable assets by 2. In other words, take 1/2. This is your community spouse protected amount. But if it's less than $24,180, and that's a 2017 number, the community spouse protected amount will be $24,180. If it's more than $120,900, and that's also a 2017 number, the community spouse protected amount is limited to $120,900. If the community spouse needs to receive property from the institutionalized spouse to get up to the community spouse protected amount, that transfer is allowed, and that amount is called the community spouse disregard. If the countable assets exceed the community spouse protected amount and the institutionalized spouse's $1,600 allowance, the institutionalized spouse will not qualify until some of the countable assets are spent down, so that only the community spouse protected amount, the $1,600 allowance, and excluded assets remain. If you disagree with the calculations made by the Department of Social Services, you can ask that they be reviewed through a fair hearing, which is like an administrative appeal. Medicaid pays for a lot of very expensive services at a time when you have a desperate need for services. The problem is that to qualify for Medicaid benefits, as we just finished discussing, you need to be poor. Except for some small allowances, all your assets must be exhausted. Naturally, then, when the need arises, you might start thinking about how great it would be if you could be poor so that you can qualify for Medicaid. And you may begin thinking about transferring your assets to family members so that the family will have the assets while you get the Medicaid benefits. And, as you may expect, the Medicaid program includes rules that are designed to thwart the perverse incentive to transfer assets so you can qualify for a welfare program. In Part 3 of this screencast, we'll be talking about the rules relating to such transfers.